Have you ever felt trapped by debt collectors demanding money you're not even sure you owe, especially while living on a fixed income? If you're over 60 and struggling to stay afloat, this could be the turning point you've been waiting for. What if I told you there are debts you might not have to pay at all? Debts that could be draining your savings without any legal obligation. Imagine the relief of knowing the law can actually protect you. Today, I'm revealing 6 surprising debts that seniors can legally walk away from. Some of these may shock you, but understanding them could save you from years of financial stress and unnecessary burden. Stay with me until the end to learn how to protect your peace of mind and keep your hard-earned money where it belongs, in your pocket. Let's begin with the first: old credit card debt that has passed the statute of limitations. This is one of the most common financial traps seniors face. Knowing how it works can spare you needless anxiety and financial loss. Picture this. It's the early 2000s and you had a credit card with a balance, maybe $2,000 or even $5,000. Then life threw you off course. A medical emergency, job loss, or interest and fees that grew beyond control. Payments stopped, the account went into default, and the debt just lingered. Years may pass, 10, 15, even 20, and you think the debt is long behind you. Then suddenly, the phone rings. A collector claims you owe thousands, piling on interest and fees. They may threaten lawsuits, wage garnishment, or even suggest taking your Social Security benefits. But here's the truth. Social Security is generally protected by federal law, so these threats are often empty. Here's what debt collectors don't want you to know. Every state in the U.S. sets a statute of limitations on debts, a time limit for creditors to sue and enforce payment. Once that period ends, the debt becomes time-barred. That means collectors lose the legal right to drag you into court. The exact limit depends on where you live and the type of debt. For credit card balances, usually classified as open-ended accounts, it's typically 3 to 6 years. Some states, like Kentucky, allow up to 15 years on certain written contracts. For example, California sets the limit at 4 years, Texas also at 4, while Ohio allows 6. To know your state's rules, you can check with the Attorney General's office or your local consumer protection agency. In practical terms, once a debt is time-barred, it may still exist on paper, but collectors can no longer secure a court judgment to garnish wages or freeze bank accounts. Debt collectors often depend on intimidation, counting on you not knowing your rights. But here's where things get tricky. Certain actions can accidentally reset the statute of limitations, giving collectors a new chance to take legal action. Even a small payment, maybe $10 to show good faith, or simply admitting the debt is yours during a call, can restart the clock. In many states, collectors are trained to exploit this. They may sound friendly, saying, "Just send us something to keep the account active," or "Don't you want to settle this old matter?" These tactics are designed to trick you into reviving a debt that is no longer legally enforceable. So, how should you respond when contacted about an old credit card balance? The key is to protect yourself. Do not admit or acknowledge the debt. Avoid phrases like, "I know I owe this," or "I'll try to pay something." Instead, remain neutral and simply say, "I need more information about this matter." From there, request written validation. Under the Fair Debt Collection Practices Act, or FDCPA, you have the right to demand a written validation notice within 5 days of the initial contact. This notice must clearly state the original creditor's name, the amount owed, and your right to dispute the debt. The best response is polite but firm. Say, "Please send me all details in writing. I will not discuss this over the phone." Then verify the age of the debt. The statute of limitations usually starts from your last payment or the date the account went into default. You can confirm this through personal records or by checking a credit report from agencies like Equifax, Experian, or TransUnion. If the debt is beyond your state's statute of limitations, it's legally unenforceable. At that point, send a cease communication letter. In this letter, state clearly that the debt is outside the statute of limitations and demand that contact stop. Under the FDCPA, collectors must comply. Always keep a copy of the letter and send it by certified mail for proof. And remember your rights. If a collector continues to harass you or threatens illegal actions, such as garnishing Social Security benefits, you can file a complaint with the Consumer Financial Protection Bureau or your state's Consumer Protection Agency. By knowing the statute of limitations and using your rights, you can free yourself from the burden of old credit card debt. You're not required to pay what's legally expired, and you deserve to live without fear of predatory collection tactics. Medical debt is one of the most painful burdens for seniors, both emotionally and financially, especially for those living on fixed incomes like pensions or Social Security. Imagine undergoing a critical procedure, heart surgery, a hip replacement, something that saves your life or restores your mobility. Then, weeks later, the bills arrive. $2,000 for lab tests, $5,000 for the hospital stay, another $1,500 for anesthesia, and more for follow-up care. Even with Medicare or private insurance, the out-of-pocket costs can feel overwhelming. When you can't pay, providers may turn the debt over to collectors, and suddenly the phone rings non-stop with demands you can't possibly meet. Here's a fact many seniors don't know. When hospitals or clinics decide a medical debt is uncollectible, they often charge it off as a business loss for tax purposes. In many cases, the debt is then sold to a third-party collection agency for pennies on the dollar, sometimes as little as 10 cents. From there, collectors use pressure tactics to recover whatever they can. But here's the important point. You don't legally owe them unless they can prove the debt is valid. Under the FDCPA, collectors must provide written validation that connects the debt to you and confirms the exact amount. Without this proof, their claims have no legal standing. In many cases, especially with older medical debts, collectors don't have complete documentation. Records often get lost during transfers from the provider to the agency. And just like credit card balances, medical debts can also become time-barred under the statute of limitations, typically 3 to 6 years, depending on the state. That's why it's essential to confirm when the debt originated. If it's past the statute of limitations, collectors cannot take you to court. Another important but often overlooked point is that many hospitals, especially non-profit ones, are legally required to provide financial assistance or charity care for low-income patients, including seniors. These programs can reduce or even erase bills, but they're rarely advertised. For instance, a nonprofit hospital may forgive 100% of costs for patients with incomes below 200% of the federal poverty line, yet most people never know unless they ask. So how do you protect yourself? First, request debt validation when a collector contacts you. They must provide a written notice that includes the original provider's name, the date of service, the balance owed, and proof that the debt belongs to you. Without this documentation, they have no legal right to collect. Next, always check the debt's age to determine when the service occurred or when the last payment was made. If the debt is beyond your state's statute of limitations, inform the collector in writing that it is time-barred and request they stop contacting you. Next, inquire about financial assistance. Reach out to the original hospital or clinic to ask about their charity care or financial aid programs. Many facilities have online applications or counselors who can guide you. Provide proof of income, such as Social Security statements or tax returns, to qualify for relief. If the debt is still valid and within the statute of limitations, check carefully for billing errors, which are surprisingly common. You may also negotiate a lower settlement, especially since collectors often buy debts for pennies on the dollar. Always secure any agreement in writing before paying. Seek legal help if necessary. If collectors harass you or use false threats, consult a consumer attorney or report them to the CFPB. Seniors can also turn to organizations like Legal Aid or AARP's Legal Services Network for free or low-cost support. Medical debt can feel crushing, but much of it rests on shaky legal ground. By knowing your rights and using available assistance, you can often reduce or even eliminate these burdens, easing both stress and worry. Now let's turn to another issue: Debt held solely in a deceased spouse's name. The loss of a partner is already devastating, and unfortunately, some collectors exploit this vulnerability by pressuring seniors to pay debts they may not legally owe. Imagine this: you're grieving the loss of your husband or wife, struggling with both emotional pain and financial adjustments. In the midst of this, a debt collector calls, claiming your spouse left behind a $10,000 balance or unpaid loan. They may insist, "This is now your responsibility," or even suggest that paying the debt would honor your spouse's memory. Some may go further, threatening to damage your credit or pursue legal action. These tactics are not only heartless, but often illegal. Here's the truth. If the debt was solely in your deceased spouse's name and you never co-signed the loan, applied jointly for the card, or agreed to be responsible, you are not legally obligated to pay it from your own income, savings, or pension. Creditors can only seek repayment from your spouse's estate, which includes assets like savings accounts, real estate, or other property held at the time of death. Even then, debts are paid according to state probate laws, which prioritize certain obligations such as funeral expenses or taxes. If the estate has no assets, creditors have little recourse. Sadly, many collectors take advantage of grieving seniors, using guilt or misinformation to pressure payment. But in reality, a debt in your spouse's name alone will not affect your credit score unless you were a co-signer or shared a joint account. Here's how to protect yourself when collectors pursue a debt in your deceased spouse's name. First, confirm ownership. Ask the collector to prove whether the debt was solely your spouse's or tied to a joint account. Request copies of the original credit agreement or loan documents. If you never signed, you're not responsible. Next, direct collectors to the estate. Let them know, ideally in writing, that repayment must go through the estate's executor or administrator, not you. For example, you might state, "This debt was in my spouse's name only. Please contact the estate's executor and do not contact me again." If the calls continue, send a cease communication letter by certified mail. Under the FDCPA, they must stop, and keeping records of every exchange gives you strong protection. Also, understand the rules in community property states like Arizona, California, Texas, or Washington. In these places, debts from during the marriage can sometimes be shared, even if only one spouse's name appears. Still, collectors must prove the claim and seek payment through the estate. Finally, if harassment or misrepresentation occurs, don't hesitate to report the collector to the CFPB or your state attorney general. You can also turn to organizations like Legal Aid or AARP for free or low-cost legal guidance. Protect your credit by checking your credit report and making sure a spouse's debt isn't mistakenly listed as yours. If it appears, dispute it with Equifax, Experian, or TransUnion, and provide documents showing the debt belongs to the estate. Losing a spouse is already one of life's hardest moments. You don't need the added pressure of predatory debt collectors. Remember, you are neither legally nor morally responsible for debts that aren't yours, and you have every right to stop harassment. By understanding your rights and acting decisively, you can focus on healing instead of battling unfair financial demands. Now, let's talk about federal student loans, including Parent Plus loans, that many seniors still carry into retirement. These debts often stem from well-meaning decisions made years earlier, helping a child pay for college or pursuing your own education later in life. With tuition costs soaring, balances can grow large, leaving older adults struggling with payments on limited incomes like Social Security or small pensions. What many don't realize is that federal student loans can be fully discharged under certain circumstances, such as total and permanent disability or death. This relief applies to multiple federal loan types, including direct subsidized and unsubsidized loans, Parent Plus loans, Graduate Plus loans, and even federal consolidation loans. If you become totally and permanently disabled, unable to work due to a physical or mental condition, you may qualify for a TPD discharge. Likewise, if you took out a Parent Plus loan and your child passes away, that loan can also be discharged. And most importantly, if you, the borrower, pass away, your federal student loans are canceled, not passed on to your family or estate. This ensures your loved ones are not burdened with your debt. The challenge is that many seniors remain unaware of these options, often because loan servicers fail to explain them clearly. You don't have to be receiving Social Security disability insurance to qualify. A physician's certification, medical records, or documentation from the Department of Veterans Affairs can also serve as proof. Unfortunately, loan servicers sometimes make the process unnecessarily complicated, leaving many eligible seniors stuck with payments they don't legally owe. That's why it's vital to take the first step yourself. Contact your loan servicer and ask about the Total and Permanent Disability Discharge Program. Request clear instructions and a list of the required documents, which may include medical records, a doctor's statement, or proof of SSDI or VA benefits. Submitting a complete application is crucial because the discharge is not automatic. But once approved, your entire federal student loan balance is erased. This can lift a tremendous weight off your shoulders, giving you the freedom to focus on your health, peace of mind, and enjoying retirement without the strain of monthly debt. 5. Debt forgiven in bankruptcy but still pursued by collectors. Bankruptcy can be a lifeline for seniors overwhelmed by debt, giving them a chance to start fresh. For many older adults, Chapter 7 bankruptcy is common because it discharges unsecured debts like credit cards, medical bills, personal loans, utilities, or even past due rent. Once the court grants a discharge, these debts are legally erased. You are no longer responsible for paying them, and the law is meant to help you regain stability. Yet here lies the problem. Some dishonest collectors still try to pursue these debts. They may call, send letters, or use intimidation, hoping you don't know your rights. But let's be clear, once a debt is discharged, it no longer exists in the eyes of the law. Collectors are strictly prohibited from contacting you under the Bankruptcy Code's discharge injunction. Any violation is serious and can lead to penalties, lawsuits, or fines against the collector. Sadly, many seniors fall victim to these tactics, assuming that if someone keeps calling, the debt must still be valid. That belief leaves them paying money they don't legally owe. Collectors often count on confusion, hoping you'll believe you still owe money that was already cleared in bankruptcy. To protect yourself, start by reviewing your bankruptcy paperwork and confirming the debt was included in the discharge. If it was, contact the collector in writing, provide your case number and discharge date, and state clearly that their actions violate federal law. If they persist, report them to your bankruptcy attorney, the Federal Trade Commission, or the Consumer Financial Protection Bureau. In some cases, you may even have grounds for legal action against them for violating the discharge injunction. Remember, the bankruptcy process is difficult enough. You took a bold step to secure a fresh start. Don't allow predatory collectors to drag you back into debts that no longer exist. 6. Small balances that cost more to collect than they're worth. Minor debts, often under $100 or sometimes up to $500, can create unnecessary stress for seniors when collectors start pursuing them. These usually come from overlooked bills, a phone cancellation fee, a forgotten gym membership, or even a small medical copay. Though the amounts are small, the repeated calls and letters can feel overwhelming. Collectors may threaten legal action or wage garnishment, but the truth is pursuing such debts often costs more than they're worth. Taking a $74 bill to court, for instance, would rack up fees that far exceed the balance. Because of this, collectors usually avoid lawsuits over small debts and instead rely on intimidation to pressure payment. In many cases, these debts get sold to another agency or eventually written off as uncollectible. For seniors on fixed incomes, even a tiny balance can spark fear that their retirement savings or Social Security might be at risk. But it's important to know most small debts don't justify aggressive action, and income sources like Social Security are generally protected. If you're contacted about a small debt, pause and carefully assess the situation. Verify if the debt is legitimate, and check whether it falls within your state's statute of limitations, the window when a collector can legally sue. If the debt is valid and you're able, you may consider negotiating a settlement. But if it's old or questionable, dispute it and request written validation. In many cases, collectors step back when challenged or when the cost of chasing a tiny balance outweighs any potential recovery. By understanding how debt collection works, you can face these situations with confidence, knowing that most small debts rarely lead to serious consequences. The key is to focus on protecting your financial well-being and never let anyone exploit your concerns over minor balances. Wishing you good health, happiness, and peace. And remember to subscribe to my channel, Healthy Aging Blueprint.